course, not legal advice. Hit the like, subscribe, scream at the screen, send it to your aunt or uncle. Please do something with it. I just kind of wanted to tell you how I found out that what can happen in the courtroom might be surprising. And it happened about in 1985. That's when the trial happened. I was admitted to practice a couple years before that. So the kind of basic factual situation, which was a ridiculous factual situation, was there was a building, a commercial building in Hollywood that was being rehabbed. The building was owned by two lawyers. And we all know how sympathetic and darling lawyers are. And those two lawyers, unfortunately, and I never really understood why, had no insurance on the building. And during this, during the time that the building was being rehabilitated, it was also occupied. So there were tenants in the building. And specifically, there was a back staircase in the building that was being rehabbed. And this particular staircase had no handrails. The lights were sporadic and partially out. The steps, so it would be like a tread and another term for the other part of the step, didn't meet code, so it was too short. So it was difficult and clumsy to walk on down them. It was dark. And it was slippery. Surprisingly, an office worker who was working in the building on one occasion fell down the stairs and injured her knee. She was approximately 35 years old, so she had a long work history ahead of her, which plays into how you calculate damages. I had a friend who was representing the lawyers at trial, and I put representing in quotation marks. He was representing them again because there was no insurance. If there had been insurance, there probably would be other attorneys that had been representing them. And the outcome of the case might have been different also, because the insurance company might have paid a significant amount of money earlier in the case. So my friend, who no longer practices law, did a terrible job, in my opinion. There were other defendants, too, who were represented by other attorneys, but they kind of relied upon my friend to take the lead. And because of the facts and the darkness and the no railing and the lights being out and the stairs not being to code and being slippery and dark, it sounded like the case was virtually defenseless. So I remember there was a 12-person jury, and I was sitting at counsel table up front, soothing my malpracticing friend. The evidence all came in. Liability was virtually uncontested because of the circumstances. The plaintiff, the party that was harmed, they put on an economist who had established that because of plaintiff's injury to her knee, she could no longer do office work, and because of her age, they calculated the loss of just her loss of future income along with medical costs at well over $2 million. There were also other potential damages, but it was at a minimum over $2 million. During the trial, before the case was presented to the jury, before it reached the jury, the lawyers themselves, out of their own pockets, offered the plaintiff $650,000. So this was literally the lawyers writing a check for that amount of money. And in 1985, that was a lot of money. And that was not insurance money. So that was real money out of their pockets. So they thought, as this case was going on, that they were in deep trouble. And again, my friend, again, who's no longer practicing, hadn't engaged any experts to contest liability, damages, the medical situation, etc. So the situation looked very, very bleak. And with regard to an offer of $650,000, the plaintiff felt so strongly about their case that they turned it down flatly and didn't even offer a counteroffer. So they didn't even come back and say, give me $2 million and we'll be done. They just said, no, we're just going to let it go to the jury. So the case goes on. It was about a 10-day jury trial. The last witness to go on the stand after everything had been established was the plaintiff herself, to offer a sympathetic face to the claims and all the expert testimony. She was seated at the rear of the courtroom. When it was her time to testify, her name was announced. She stood up from the back of the courtroom and proceeded to walk from the back of the courtroom to the witness stands as her high heels made a clickety-clack sound repeatedly, drawing the attention of the jurors. And as I sit here today, I still remember how that sound drew the attention of everyone. The plaintiff, prior to the trial, had been paid approximately $20,000 through the workers' compensation system. And the way that works is once workers' compensation pays out money, if there's a lawsuit, they have a lien, so a kind of basically a right to collect against the monies that are collected in the lawsuit until they get back the money they put out. So they were paid $20,000 through the workers' compensation. And in the lawsuit, the split likely would have been 60-40, so 60% to the plaintiff, 40% to the lawyer. Could also have been some other combination, but since it went all the way through trial, that's probably what the split was. So the jury was not out very long. They obviously found against the landlords, the lawyers, and awarded plaintiff, who through the unrefuted expert testimony had established arguably damages in the millions, approximately $16,000, all of which went to satisfy the workers' comp claim. So to me, it was plaintiff, step by step, who decided the case. And that kind of gave me insight that I never know what's going to be the element of evidence or performance that's going to ultimately decide the case. And I'm often surprised, and that's why it's hard to get a lawyer to predict an outcome, because you really never know.